This is secured transactions, statements of law for the bar exam. Security interest. Under Article 2 of the UCC, any retention or reservation by the seller of the title in goods that are shipped or delivered to the buyer is limited in effect to a reservation of a security interest. Attachment is the process by which the security interest is created. The security interest attaches when the secured party gives value, the debtor has rights in the collateral, or the power to transfer rights in the collateral to a secured party, and the debtor has authenticated a secured agreement that sufficiently describes the collateral. A security agreement is an agreement that creates or provides for a security interest in certain collateral. The security agreement specifying an interest in inventory will create an interest in after acquired collateral. Inventory is a type of goods and includes raw materials, work in process, or materials used or consumed in business. Perfection. Perfection is the process by which the secured party gives notice to the entire world of its security interest. A secured party perfects its security interest in goods by filing a financing statement or taking possession of the collateral. Perfection is necessary for priority purposes. The general rule regarding priority is first in time, first in right. Among unperfected security interests, the first security interest to attach will prevail. Between two perfected security interests, the security interest with the earliest timing of filing of perfection, or perfection, whichever is earlier, which has continued without interruption, will prevail. A perfected security interest has priority and will prevail over an unperfected security interest. Purchase money security interest is where the money is provided at the time for the purchase of the collateral in question, and takes priority over all others as it perfects and attaches at the moment. Breach of contract under the UCC. Upon a buyer's breach of a contract for the sale of goods, the seller is free to cancel the contract and to withhold delivery of any yet to be delivered goods. Under the UCC, the buyer does not have title to goods until the seller delivers the goods. The rules regarding attachment are stated above. Security interests. Security interest is enforceable against the debtor and third parties with respect to the collateral if 1. Value has been given. 2. The debtor has rights in the collateral or the power to transfer rights in the collateral to a secured party. And 3. The debtor has authenticated a security agreement that provides a description of the collateral. Under Article 9, goods that are held for sale are inventory. A security interest attaches to collateral when it becomes enforceable against the debtor with respect to the collateral. Generally, a financing agreement statement must be filed to perfect a security interest, but no filing is required to perfect a purchase money security interest in consumer goods. Does the security interest continue after the successive sale of a good? As a general rule, a security interest continues after sale of the collateral. However, that general rule is subject to many exceptions, one of which applies here. Buyer in the ordinary course of business takes free of a security interest created by that buyer's seller. A buyer in the ordinary course of business is a buyer who buys goods in good faith without knowledge that the sale violates the rights of another from a person in the business of selling goods of the kind in the ordinary course of the seller's business. Does a security interest prior to the sale of a good become enforceable after the sale? Attachment. A PMSI in consumer goods perfects automatically upon attachment. Thus, upon the sale, it has attached and perfected under a PMSI, and therefore the prior security interest does not apply. Is that same security interest applicable to the seller? A buyer in the ordinary course of business takes free of a security interest created by the buyer-seller, even if the security interest is perfected, and the buyer knows of its existence. Also, a buyer of consumer goods takes free of a security interest in those goods if the buyer buys without knowledge of the security interest, gives value, buys for personal, family, or household use, and receives the goods before the filing of any financial statement covering them. Attachment and perfection again. Attachment is the process by which the security interest is created. The security interest attaches when the secured party gives value, the debtor has rights in the collateral or the power to transfer rights in the collateral, and the debtor has authenticated a security agreement that sufficiently describes the collateral. Inventory includes goods other than farm products that are held for sale. Perfection is important for priority purposes, and a secured party perfects its security interest by filing or taking possession or control of the collateral. The most common way to perfect a security interest is to file a financing statement with the Secretary of State's office. The retention or reservation of title by a seller of goods is limited in effect to a reservation of a security interest. The substance of a transaction controls rather than its form or the label given to it by the parties. Perfected security interests have priority over unperfected security interests. Equipment is a catch-all category, defined merely as goods other than inventory, farm products, or consumer goods. This term usually refers to goods that are used or bought for use primarily in a business. The rules regarding attachment and perfected are above. A transaction creates a security interest even if called a lease, if the consideration for the right to possession and the use of the goods is an obligation for the term of the lease, not subject to termination by the lessee, and the lessee has an option to purchase the goods for no or nominal additional consideration at the end of the lease. The rules regarding attachment and perfection are above. Perfection. Perfection is the process by which a creditor notifies the entire world of his security interest in collateral. Filing a financing statement in a public office is the most common way to perfect a security interest. General rule regarding priority of security interest is first in time, first in right. This means that the first creditor to secure a lien on collateral has priority. A security interest generally survives the sale of the collateral. However, a buyer in the ordinary course of business takes free of a security interest created by the seller. Buyer in the ordinary course of business is a person who 1. Buys goods in good faith, 2. Buys without knowledge that the sale violates the rights of another person in the goods, and 3. Buys in the ordinary course from a person in the business of selling goods of that kind. A security interest will attach to the goods identified in the security agreement. Collateral subject to a security interest may also be in the form of proceeds obtained from the disposition of other collateral. Where a good is acquired in exchange for collateral, the good is deemed to be proceeds from the disposition of that collateral. Where proceeds subject to a security interest are subject to obtain other goods, these goods are considered non-cash proceeds and will be subject to the original security agreement. Absent specific circumstances, such goods will only be automatically perfected for 20 days. If the secured party perfects its interest in the proceeds during this period, the perfection will relate back to the original filing. However, the automatic perfection will be permanent where a filed financing statement covers the original collateral, the proceeds are collateral in which the security interest may be perfected by filing in the office in which the financing statement has been filed, and the proceeds are not acquired with cash proceeds. Purchase money secured interest. Perfection is a process by which the secured party gives notice to the entire world of its security interest. A secured party perfects its security interest by filing a financing statement in a public office or taking possession or control of the collateral. A security interest in a purchase money security interest, if it pertains to goods, called purchase money collateral, the purchase of which was facilitated by the security interest, now secured by the same collateral. Perfection is necessary for priority purposes. A perfected purchase money security interest takes priority over all previous liens. A purchase money security interest perfects an attachment of consumer goods, but not inventory, which must be perfected by filing in the appropriate office. A perfected interest takes priority over an unperfected interest. Judgment liens take priority over unperfected liens. Accounts. Accounts are rights to payment of a monetary obligation, whether or not earned by performance, generally for property that has been transferred or otherwise disposed of, for services, or arising out of the use of a credit or charge card. Inventory are goods that are 1. Are leased by a person as leasor. 2. Are held for sale or lease or to be furnished under a contract of service. 3. Are furnished under a contract of service. Or 4. Consist of raw materials, work in process, or materials used or consumed in business. Lastly, equipment refers to goods that are used or bought for use primarily in a business and do not fall into the other categories of goods. Whether or not a judicial lien or a creditor on the same property takes interest. The first in time, first in right rule applies in priority contests between lien creditors and secured parties. Therefore, a secured party will have priority over a lien creditor if the secured party 1. Perfects before the lien creditor's interest arises, or 2. Files a financing statement and evidences a security agreement before the lien creditor's interest arises. UCC Article 9 applies to any transaction regardless of its form that creates a security interest in personal property or fixtures by contract. Default. Default occurs when a debtor fails to tender an obligation when it is due. Upon default, a secured party may repossess tangible collateral if it can be done without a breach of the peace. Actions likely to lead to violence or entering a private home are considered a breach of the peace. Purchase money secured interest in fixtures. The general rule for priority of security interests is first in time, first in right. A PMSI may be second in time but first in right if the PMSI is for a fixture and a fixture filing is completed. A fixture is A. Attached to real estate, B. Adapted to the use of the real estate, and C. Intended to be a permanent attachment. The fixture filing must be made in the county office where the land records are kept, describing the land involved. A purchase money mortgage is a mortgage given to a secure loan that enables the mortgager to acquire title to property. Mortgages to give notice are filed by the in the county office where land records are kept. A security interest in proceeds is automatically perfected for 20 days, after which a filing describing the proceeds must occur, unless the proceeds are identifiable cash. Sale of collateral. After default and repossession, a secured party may sell, license, or otherwise dispose of any or all of the collateral in its present condition, or following any commercially reasonable preparation or processing. Before disposing of collateral, the secured party must send to the debtor and any secondary obliger a reasonable authenticated notification of disposition. This requirement does not apply to collateral that is perishable, that may decline quickly in value, or that is a type customarily sold on a recognized market. I think that's collateral. If the collateral consists of accounts receivable, instruments, or chattel paper, the secured party may, upon the debtor's default, notify the person obligated on the collateral to make payment to the secured party. Notification must 1. Be authenticated by the secured party or the debtor, and 2. Reasonably identify the rights assigned. Once notified, the account debtor may discharge its obligation only by paying the assignee and is not discharged by paying the original obligee. A description of collateral is sufficient if it describes the collateral by UCC type. A supergeneric description such as all the debtor's personal property is not sufficient in a security agreement. Equipment is a category of collateral, defined by the UCC as goods other than inventory, farm products, or consumer goods. Attachment. Attachment is the process by which the security interest is created. The security interest attaches when the following elements exist simultaneously. 1. The secured party gives value. 2. The debtor has rights in the collateral or the power to transfer rights in the collateral to a secured party. And 3. The debtor has authenticated a security agreement that sufficiently describes the collateral. A security agreement may provide for an interest in after acquired collateral. Perfection is the process by which the secured party notifies the world of its interest. Perfection is important for priority. A party perfects its security interest when the interest is attached and the requirement for the perfection are met. Perfection can be done by filing or taking possession or control of the collateral. Filing a financing statement in a public office is the most common way to perfect a security interest. General rule regarding priority under Article 9 is first in time, first in right. Between two perfected security interests, the security interest with the earliest time of filing or perfection, whichever is earlier, which has continued without interruption, will prevail. A perfected PMSI in goods other than inventory will prevail over a conflicting security interest if the PMSI is perfected when the debtor receives possession of the collateral or within 20 days thereafter. This has been Secured Interests for the bar exam.